At the A4ID Intellectual Property event on Tuesday the 26th of June 2012, Dr. Mike Adcock of Durham University spoke on the role that international and domestic law can play to ensure farmers' rights in developing countries are protected.
Wow, you covered a huge amount of ground in your talk that I'm not going to be able to sort of match in any way. So I'm going to focus on a particular issue within that, and then maybe at the end, if we can expand on certain things that you mentioned, that will be good. I just quickly to start, I put a picture of UK and Durham up there because I know that a lot of you as Londoners, once you get past Watford Gap, get a bit nervous. So just to point out how far away Durham really is. Actually, it's only 3 hours on the train, it's not that bad. Just a bit of background about myself. I did a PhD in plant sciences, and then I did a law degree, and then I sort of worked in the area on an EU-funded project looking at plant protection, so plant variety rights and patents within what was then, it was a long time ago, was within the 15 EU member states. So the presentation is going to be in 4 parts. A very quick overview of GM crop production, a short overview of plant intellectual property protection on a sort of global scale, and then look at some different approaches that different countries have taken towards some of these issues, and then look at some of those issues at the end and see if there are any way of resolving some of the things that occur. So, a brief overview of GM crops, and this is taken from the ISAA report for 2011. And I think what this one is sort of trying to show is how widely grown GM crops are. They're grown obviously in North America and largely South America, Brazil, Argentina. They're grown in Asian countries, India, China, Philippines, they're grown in Australia, they're grown in South Africa, as you mentioned. There's also a small amount in Burkina Faso, and there's a very small amount in Egypt. And as we probably know, we're very limited in the way that they're grown in Europe. In fact, the only real GM crops grown in Europe tend to be for feed, in other words, animal feed, not for human consumption. Just picking up a point there, part of the reason why GM crops, there are several reasons why GM crops are hardly grown in Europe at all. One of them is a rejection by society to a large degree. The second one is the regulatory hurdles that are in place to actually get a GM crop through the regulatory system from the laboratory to the marketplace. They are incredibly tough and incredibly difficult. Now, in contrast to the States, we don't have this idea of substantial equivalence. We have to go through all the normal safety tests that you would do for a new food product. So they're extremely rigorous. Again, in contrast to the States, within the EU, we do have labelling issues, and we do have issues around for coexistence. In other words, how you can grow a GM crop when you're near another non-GM crop. And the liability rests purely with the farmer, and the responsibility rests with the farmer to implement those coexistence regulations to make sure that there is minimal risk of contamination of any fields around him. Now, we live in a biological society. There is no such thing as no risk. What these tend to do is try and minimise risk or mitigate risks. There's no such thing as no risks. Going back to this, I think, got to the next slide anyway. GM crops grown in 29 countries across the world. 19 of those are classified as developing countries. Developing countries now grow close to 50% of global biotech crops, and approximately half the world's population live in countries growing GM crops. In fact, over half the world's population live in countries growing GM crops. Now, as absolutely rightly pointed out, there's a lot of issues about what traits are out there, and there are really only 2 traits: the herbicide tolerance and the pesticide, I got the wrong around, herbicide resistance and pesticide tolerance traits. But I think what this ISAA report is saying, along with a report from the JSC, which is a European group looking at the potential for GM crops, is they're saying that there are some things on the horizon, but they are 10, 20 years away, and drought tolerance is probably not one of them. The sort of things probably looking at are changes in the composition of a particular oil or particular food to make it more suitable for particular food processing area. But also, because of the high investment in Asian countries and to a lesser extent in Latin American countries, it's likely to be that there will be developments coming out of India, China, and perhaps to a lesser extent Latin America. So, a quick overview of intellectual property on a sort of global scale. Now, I don't know what people's backgrounds are, so sometimes I'm going to use some jargon. If you're not sure what I'm talking about, please just say so. As, again, correctly mentioned, the World Trade Organization, WTO, has an agreement called the Agreement on Trade-Related Aspects of Intellectual Property Rights. And if you're a member of the WTO, you have to have set down these minimum standards of intellectual property rights. And it covers trademarks, copyright, patents, geographical indications, and so on. But focusing purely on the patent system, you have to have these minimum standards in your country national legislation if you want to be a WTO member. Within those, the framework that governs the way you could implement a patent system at a national level comes a few exclusions, and these exclusions are based very much on what was already found within Europe under the European Patent Convention. So members, in other words members of the WTO, may exclude from patentability plants and animals. I'm missing off the whole bit in the middle, but they must protect plant varieties, and they must do this either by patents or an effective sui generis system, or a combination of both. So in other words, if you're a developing country, you join the WTO, you're faced with a system where you need to introduce a patent system, a patent regime. You have the possibility of excluding plants and animals, but you also have to provide protection for plant varieties, either by patents or by a sui generis system. And as again absolutely pointed out, the main sui generis system that covers plants are plant variety rights, which are these extremely niche area which most lawyers will never even touch, even if they study IP. So I'm one of those plant nerds, as you said. There have been several conventions, 3 conventions under UPOV. And the first one, 1961, was fundamentally a European idea for giving plant breeders some way of protecting their new varieties they bred. Subsequent revisions been in 78 and 1991. I think the thing to point out is when TRIPS was sort of coming around in the sort of 90s, and the requirement for developing countries and least developed countries to implement an IP regime, there was also a changeover in the UPOV regime. So we were moving from the 78 convention to the 1991 convention. And so at one point, if you were, shall we say, fast enough, you could join the 78 convention. If you were a little bit slow in realising what was going on and the 1991 convention had come into force, then you have to join the 1991 convention. Now we may say, well, does it really matter that much? But if you're a developing country, yes it does. And the reason being, the 1991 convention made the breeders' rights much stronger. It covered all species of plants, where before the convention was limited in what it covered. It extended the duration, it extended the rights associated or given to a breeder and associated with the plant variety right. It removed the dual protection idea. In other words, you couldn't hold both a patent and a plant variety right over the single piece of material. But probably most importantly, the 1991 convention removed the farm save seed derogation, or limited it hugely in a way that can possibly operate. Now, if you're a developing country with a where your agriculture is a huge part of the economy and a huge part of people's daily lives, then farm saved seed, and the saving of seed, the exchanging of seed and the selling of seed was a crucial part of your agricultural economy. And by limiting that, it meant that developing countries are really not going to join the 1991 convention. Now, looking at the way some of the members of, this is not an exhaustive list of members of UPOV, this is purely ones picked out, but I think the things I want to show you are big GM producers: Argentina, Australia, Brazil, Canada, China, are all members of UPOV. The only Asian countries that are members of UPOV are China, Singapore, Korea and Vietnam, and only China out of those was a member of the 78 convention. In Africa, only South Africa and Kenya, sub-Saharan Africa, are members of UPOV. Egypt is also a member of UPOV. And you can see, therefore, quite clearly that although the developing countries had to introduce some form of protection for plant varieties, they didn't like the UPOV format. 4 Asian countries, 3 African countries, they were not, and partly also because if they were slow in implementing a regulation, they would have had to introduce the 1991 convention rather than the 78 convention and the farm saved seed provisions. And as you can see, the EU is a member of the 1991 convention. A quick look at the very quick overview of the patent system. And this is probably pertinent now when we're talking towards GM stuff. The TRIPS, we mentioned before, WTO agreement, means that members of the WTO must provide patents for inventions, whether they're products or processes, in all fields of technology. You cannot exclude a technology from being patented. You can't say, well, it's too important that drugs are given access. They have to be patented if you're a WTO member. And that, therefore, applies to potentially to things that come out of plants, in other words, plant DNA, plant genes, and so on. So you had to introduce a patent system which covers all fields of technology. You could, as a developing country, exclude plants from being patented, but you had to look for a sui generis system. Where might you look for a sui generis system or a patent system that might be appropriate? You might look at Europe for guidance. You might look at USA for guidance. If you look for USA, Diamond Chakrabarty, patent everything under the sun, may not really fit in with what your feelings are regarding protection of plants. Europe, again, European Patent Convention has that optional exclusion that we found under TRIPS and WTO, and at the time most countries were implementing a patent regime. The Biotech Directive, which came out in 2000, didn't really exist. So, again, looking at some developing countries have looked to the European Patent Convention as a way of formatting their patent regime, patent system. So, what about some different approaches? How have some countries, especially developing countries, thought about protecting or meeting their obligations under TRIPS? In other words, having some form of system of protection for plant varieties. Let's take Thailand. Thailand brought out a Plant Variety Protection Act in 1999 partly to meet their obligation of joining the WTO. It's very much based on UPOV 1978 because they couldn't join it at that time, but they could use the 78 Act as a framework because the way TRIPS is worded, they can introduce their own sui generis system. They didn't have to implement UPOV. And they also took some concepts from the CBD, which is the Convention on Biological Diversity. Because they're introducing their own system, they could introduce a system that didn't protect all plant species. They could limit the number of species that could be protected. They had a wider range of categories. So yes, they had new varieties that had to meet the DUS test that we were talking about, distinct, uniform and stable, but they also introduced things that were called farmers' varieties. They also introduced something that was called domestic varieties, and also introduced something that was called a wild variety. And so these different types or categories of varieties had to meet different criteria to get protection. So yes, a new variety had to meet the high criteria of the DUS test, but a domestic variety or an endemic variety or a wild variety or a farmer's variety could still get protection without meeting those same high standards. There was still a registration, or at least in theory, a registration system in place to allow that to occur. Thailand recognises farmers' rights. It wanted to protect farmers' rights because it realises how crucial the agricultural industry is to Thailand, to its society, and to its food production, food security, food sovereignty. As I mentioned before, they introduced some concepts from the CBD, things to do with benefit sharing and informed consent, which is partly to do with accessing those varieties. So if you have a domestic variety, a farmer's bred variety, or a wild variety, it could be that somewhere in there is some important gene. As we mentioned before, it could be that they do have the drought-tolerant genes, or they do have some salt-tolerant genes. If a company, therefore, wants to have access to those genes, there, at least in theory, is a system in place that controls access and ensures that benefit from any development using that plant and having access to that plant, any benefit from, say, an intellectual property right or a new drug on the market or whatever, feeds back into through a benefit sharing system. They also introduced the biosafety concepts for GM plants, which is based to some extent on the way that the Europe looks at it, but also taking concepts in from the Cartagena Protocol, which is the UN protocol governing a trans-border movement of GMOs. The Thai Patent Act used the exclusion of the TRIPS, excluded from patenting animals or plants. Lovely. It also excluded any substance extracted from animals and plants. Now, unfortunately, it's really unclear what this means. What is a substance extracted from a plant? Is it actually referring to genes here? Are they actually excluding genes within their patent law? There's no case law really to show how this works at the moment. It could even be that it goes further than that in what it means a substance. It could be a chemical that you actually remove from a plant, could not be patentable. But it's unclear exactly what it means. But they have introduced process patents, and as rightly mentioned, a process patent extends or can extend to give protection to the plant. So if you've produced a process where you've managed to insert a particular gene into a particular plant, and that process meets the normal granting criteria, inventive step, novelty and industrial application, and then you get a patent over that process, the scope of protection given to you gives you protection over the plant. And that's something, scope of protection, that we'll refer to right at the end. So what you could say here is that Thais have gone out of their way to recognise farmers' rights, to have this different ideas about what varieties and different categories of varieties, but maybe or possibly fall foul of the patent law if they start getting into the area of GM. So we have that potential problem where if they do move into the area of GMs, the plants are patented or the plants are covered by a patent, and therefore we move to that idea about restricting farmers' access to the seeds and restricting farmers' rights. India, they introduced a Protection of Plant Varieties and Plant Rights Act in 2001. A lot of sort of similar concepts. Again, we have a range of categories of plants. We have the new plant varieties, we have farmers' varieties, we have extant varieties, and we have wild varieties. And these can be protected in some ways, or at least registered in some ways. They also recognised farmers' rights, and they gave quite strong farmers' rights in that farmers are allowed to save and to reuse and to sell seed, provided that seed has not been branded. So if it's been produced as a farmer's variety or is covered by a plant variety right, they can still use it and save it to use on the following year, and still exchange that seed. But they can't sell a branded right. So if it's a non-branded plant, they can sell it. If it's a branded seed, they have still the rights to save it, still the rights to use it, still the rights to exchange it. They just can't sell it. So there's no commercial aspect there. So we're seeing within the Indian Plant Variety Rights Act a recognition of the contribution farmers make to biodiversity, to recognising local varieties, to recognising the traits in those local varieties. They recognise the important contribution that farmers make to the Indian agricultural sector. In India, they have a large both private and plant breeding sectors, but even those two sectors combined could not produce enough seed that India would need to use, or Indian plants, every year. They have to have farmers growing seeds, saving seeds, exchanging seeds to keep their agricultural industry as it is. So that is why farmers' rights are so important within India. The Indian Patent Law again has introduced in response to WTO TRIPS agreement, and contains this exclusion: plants and animals are excluded in whole or in part thereof. Again, it's not quite clear what we mean by or part thereof, but it possibly could mean that we're excluding plant genes from being patented. But it certainly includes patents over seeds, over varieties and species, and essential biological processes. Two things that are happening at the moment. Again, we saw with it in Thailand, we're seeing process patents, and process patents don't seem to have been picked up here. Again, if we have a process patent on producing or inserting a gene into a novel way, an inventive way into a particular plant, it could be that process patent gives you protection over that plant. So it could be we're seeing, though they have exclusion over plants and parts of plants, that gene might come from bacteria, doesn't cover the exclusion, and then we end up with a process patent that gives you the scope of protection over that plant. So we're seeing potentially a sort of back way in. And there seems also to be a push that genetically modified gene sequences can be patented. There's still some argument, but it seems likely that they can be under Indian patent law. So we're seeing, what I'd say is, this introducing a plant variety system that really recognises farmers' rights and introduces a system that is very applicable towards the Indian agricultural sector, both at the high end of private and public plant breeders to the low end of farmers. But at the same time, the patent law may have a few issues with a few loopholes in that you can see good lawyers exploiting. I won't very briefly look at the African model law, because I assume that a lot of what this would be in the film. But basically there is an African Union model law for the protection of farmers and local communities and breeders, with an idea of recognising the rights that all these people contribute to the agricultural sector, and trying to ensure a balancing of those rights and an equitable sharing of the benefits that arise when these rights are utilised. And enshrined in the African model law, so in other words, this is a framework law that you can implement at a national level. There is this idea that farmers have the rights to save, use, exchange or sell farm-safe seed or propagating material of farmers' varieties, or save, use, multiply and process farm-safe seed or protected varieties. So similar, again, to the Indian position, the main difference between a farmer's variety and a protected variety is the issue: you can't actually sell it. You can exchange it, you can use it, you can multiply it, you can save it, you just can't make a profit from selling somebody else's seed. Now, going back to what I said at the beginning, and you're a developing country, you're looking around, maybe you're looking at the EC or the EU to think, well, we'll dismiss their laws, they're based on 1991 UPOV, they don't really tell us anything that we want to know. But sometimes it's worth looking a bit deeper. Yes, the EU-wide community plant variety right regulations are based on UPOV 91, but at the national level, at the member state level, we see differences in the way that the plant variety right system operates. We see that different countries are still members of different conventions, UPOV conventions. The 78 convention in France, for example, 1991 in UK. We also see differences within the law. The Dutch have a different system, the Germans have a slightly different system, the Belgians, the French. They have tweaked, shall we say, their plant variety system to make it slightly, within the flexibility that exists within law, to make it slightly more appropriate for their plant breeding sector at the national level. So the Dutch system, or let's just say the German system or the French system, they've tweaked it towards allowing the plant breeder's right to extend into the patent area. The Dutch have a huge horticultural sector. They allow slightly more protection or different protection for the horticultural sector because that's one of their big sectors. So we do have diversity within the law within the EU. We do have the farmers' privilege system, as it's called within the EU. It allows farmers to, they're permitted or freely permitted upon a payment to save seed from one year to the next. But there are limitations placed on that. The limitations are things like only certain seeds are covered or certain crops are covered. The royalty payment, if you save seeds, is generally speaking between 45 and 60% of what you would pay to buy those seeds in the first place. And the idea is we're balancing the rights between the farmers and the rights between the breeders. And in the UK we have the National Farmers Union and the British Society Plant Breeders have come up with an agreement called Fair Play that collects royalties from farmers who save their seed to replant the following year, and collects those royalties in, and they're distributed to the breeders. A couple of things to probably notice here. One, royalty payment, 45 to 60%, agreed by the NFU and the Society of Plant Breeders. The small farmer exemption. A farmer whose land is less than 18 hectares or produces less than 98 tonnes of a particular harvest is exempt from the royalty payment. They can still save the seeds, they don't have to pay the royalty payment, but they can only save the seeds that are on the list. They're just exempt from the royalty payment. Quick look at patent law then. Is there anything we can learn from the patent law within Europe? And probably the answer looking at here is no. When we look at the European Patent Convention and we look at the Article 4 of the Biotech Directive, we see plant and animal varieties are excluded from patenting. Wonderful, that's because we have a plant variety rights system. But the patenting of plants is permissible provided a technical invention can be shown and plant variety is not claimed. Which means if you put a gene into a plant, you're claiming either the gene or the plant or the process, you can have a patent over the plant. Novartis decision 2000. It means GM plants are patentable. Plant varieties aren't patentable, plants are patentable. Lovely bit of distinction as our lawyers love to make. So you can't learn much from the patent law as to whether the exclusion of plant or plant varieties. But perhaps you can learn something from the patent law after all. Farmers' privilege, as it's called, or farm safe seed, is found in community and national plant variety rights systems. It was implemented through the Biotech Directive into the National Patent Acts. So farm safe seed provisions apply equally to plant variety right protected or patent protected plants. So in the UK we now have Schedule 1 of the Patents Act, God, I can't remember, amended 2000 and something, is now, it contains the same provision as we found under plant variety right regime to do with farm safe seeds. So farmers can save the seeds for the following year on payment of a particular royalty set by the agreement between the British Society of Plant Breeders and the NFU, but they can only save those varieties and types of crops as listed under that particular provision. But even if that's plant plant is patented, you can still save the seeds. So maybe there is something you can learn, after all, about the way the EU works. So a couple of issues. Developing countries have had to implement plant variety right legislation or patent legislation to meet their obligations under TRIPS. Most, if not all, developing countries do not like the idea of patents over higher life forms or patents over plants or animals. They've taken the option exclusion. Therefore, they've had to introduce some form of plant variety right system. They didn't like UPOV. They've mostly gone a sui generis way, especially in Asia or to a lesser extent Africa, a sui generis way, and introduced their own system, using some of the flexibility that existed within the 1978 UPOV Convention, using that as a framework. But when they've introduced, in some cases, when they've introduced a patent law to meet those obligations under TRIPS, there are potential issues there about what can be protected under that patent law. And we can see even within Europe, when we make a distinction between a plant and a plant variety, even though a plant in its protection encompasses all plant varieties, we make that wonderful distinction. If a smart lawyer goes into one of these, India or Thailand, they are probably going to be able to use the uncertainties within the patent law as they exist to allow GM crops to be patented. So maybe we need to actually go back and look at not the overarching law, the inclusion of plants, but maybe some of the details we can put in within PVR or patent law, but that takes advantage of the flexibilities of that law. Now, we've done it in Europe to some extent, and it's TRIPS compliant. Why can't it be done in developing countries and still be deemed as TRIPS compliant? So, the farm size exclusions, why do they have to be 18 hectares? Well, it's because that is a small farm on a European basis. It is possible you can set your own standard for what a small farm is at your own national level. The farm safe seed provisions in PVR and patent law, put them into your patent law as well. They don't have to be the same as what we have. They could be similar to what you already have. In other words, you allow farmers to exchange, to use, but not to sell branded varieties. If you have decide to set a level of remuneration, you can set it yourself. It doesn't have to be 40 to 60%. It can be set at a completely different level. It can be set that only branded plant varieties will actually need to fall under any idea of remuneration. And then there's three things at the end there that I'm going to talk about the second to last one first, contract laws and TUAs. We mentioned the technical use agreements or the technical use and stewardship agreements that companies like Monsanto use when they allow you to grow their particular GM crop. Because as you mentioned, you don't buy it, you license the technology. And this is basically a licensing agreement. And they're very strong, fairly strong things about what you can and cannot do under the technical use agreements. One of the problems is the contract the technical use agreement can circumvent the IP laws of farm safe seed. They can write into it that you're not allowed to save seed from one year to the next. And contract law in that way will actually trump the IP law. So it's something that we need to look, or needs to be looked at, is how we cope when there's a conflict of rights. Well, we cope in this case with contract law winning. But how do we then find a way that the IP law that exists can actually be utilised if someone's put it into place in their national level? The other issue at the bottom there is political pressures. There's always going to be political pressures on developing countries as to what form their intellectual property should take. If they join a free trade agreement with the EU or US, they're going to have to go above what the TRIPS standards requires. They're going to have to join UPOV. So there's always a balance between what you can gain from some trade agreement and what you lose by potentially a higher standard or potentially inappropriate level of intellectual property rights. because essentially what you're trying to do is use the flexibility within TRIPS to introduce intellectual property rights that are most appropriate for your level of development. And lastly, the sort of issue there is about variety replacement. What is IP fundamentally there for? It's to encourage people to carry out research. It rewards them for their research when they discover a new gene, invent a way of putting that gene into a plant, breed a new plant variety that has a higher yield or nicer tasting fruit. If we don't have a system in place that actually provides the incentive to plant breeders, then you won't get a lively and productive plant breeding sector at a national level. Thailand, it doesn't matter, they don't really have a plant breeding community. They're very much reliant on what farmers do. India is a different case. They have a large private and public sector, but the private sector within India is focusing almost exclusively on hybrids, because yes, hybrids have higher vigour, they grow better for 1 year. You can't use them the following year, or any benefit you got from the 1 year is completely lost the following year. You need to reuse, or you need to buy hybrids every single year. So that negates the farm safe seed provisions that they have in India. And you could argue that potentially it's the broad farm safe seed provisions which have caused the private companies to focus on hybrids, because it gets around those provisions, arguably. The public sector focuses on open and self-pollinated plants, so things like rice and wheat and so on. And you can argue that the public sector doesn't need IPs as a huge incentive. They're the public sector, they're financed by taxpayers and so on. And so you can argue that you can get a thriving public and potentially thriving private plant breeding sector by having the right IP laws in place that allows for variety development, that allows for variety replacement. But India, as you see, maybe their laws aren't promoting that. When you look in Europe, we have stronger IP rights. We have quite a lively plant breeding community. I think I'll leave it there, because Plant Geek can go on for hours. But thank you.
Great. Thank you very much.